Welcome to this explainer. Today we're unpacking an absolute legal and political earthquake that just shook the Capitol. In June 2025, the Supreme Court handed down a landmark ruling that struck down President Trump's executive order aimed at ending birthright citizenship. Now, this matters immensely because it sets up a monumental shift in the future of American immigration, and honestly, it redefines the limits of presidential power. It's a decision that has set off an absolute scramble in Washington, pushing lawmakers and the administration to urgently search for alternative routes to achieve their goal. So let's dive right into exactly what happened, and more importantly, what this massive shift means for the future.
The central hurdle for the administration right now stems directly from this exact date, June 30, 2025. In a really definitive 6-3 ruling in a case known as Trump v. Barbara, the Supreme Court officially blocked Executive Order 14160. This order was the administration's main tool to try and end birthright citizenship through executive action. Well, the court's decision firmly closed the door on the president acting alone on this issue. It completely blocked that solo path, essentially sending the administration and its allies straight back to the drawing board. To really grasp why the court ruled the way it did, we have to look at the foundational legal text at the heart of this entire debate. We're talking about the Citizenship Clause of the 14th Amendment. It plainly states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That single sentence is the absolute bedrock of birthright citizenship in America. But notice that middle phrase, subject to the jurisdiction thereof. That right there is where this entire legal war is being fought. Does it apply to absolutely everyone on U.S. soil or only to legal residents? That interpretation is exactly what divided the highest court in the land. What's super fascinating here is how the justices actually split on their reasoning. On one side, you have Chief Justice John Roberts writing the majority opinion. He stated that the 14th Amendment's clause strictly applies to the children of illegal immigrants and legal temporary visitors. But then, in a concurring opinion, Justice Brett Kavanaugh took a totally different angle. While he agreed the executive order had to go, he pointed to federal law instead of the Constitution itself. He argued that Congress could, potentially, amend the Immigration and Nationality Act, or the INA, to establish exceptions. And that specific legal nuance, it opened a brand new doorway for lawmakers. So, where does that leave the administration today? Well, we're going to explore the roadmap forward by looking at 4 things. 1, the legislative alternative. 2, 14th Amendment legal hurdles. 3, the constitutional amendment barrier. And 4, targeting birth tourism. Let's jump right into Section 1, the legislative alternative. Almost immediately after the ruling dropped, President Trump made his strategy crystal clear on Truth Social. He clearly believes the solution doesn't actually require changing the Constitution at all. He wrote, "The Supreme Court upheld birthright citizenship, which is too bad for our country, but we can easily make it up in Congress through legislation. No long and unwieldy constitutional amendment is necessary." This signaled a major, immediate political push to just bypass the amendment process entirely and rely strictly on statutory law. Taking a direct cue from Justice Kavanaugh's concurrence, lawmakers sprang into action. Enter Senator Eric Schmitt, who proposed the American Citizenship Act. This proposed legislation is designed to amend that decades-old Immigration and Nationality Act we mentioned earlier. Specifically, it would change the wording to mandate that at least one parent must be a United States citizen or a lawfully admitted permanent resident at the exact time of the child's birth in order for that child to automatically receive citizenship. But as we all know, writing a bill and having it actually survive a court challenge are two very, very different things. And that brings us to Section 2, 14th Amendment legal hurdles. The big, looming question here is this. Can a regular law just override a constitutional amendment? Well, legal experts are highly skeptical. John Hsu, a constitutional law expert who served in both Bush administrations, weighed in on this exact issue. He noted, let's assume that Congress was able to amend the INA to delete birthright citizenship, which is a big assumption. I don't think it would survive a constitutional challenge. Basically, the consensus among experts is that because 5 justices just ruled that the 14th Amendment itself ensures this citizenship, a mere federal statute just isn't going to fly. However, the legal landscape is never permanently frozen. Former federal prosecutor Niyama Ramani pointed out a really fascinating caveat about playing the long game. While he totally agrees the legislative approach won't work right now, things could look vastly different in, say, 5 to 10 years. Lawmakers might pass a bill today fully knowing it will fail just to have it ready for a future court.
Think about it. If the composition of the Supreme Court shifts down the line, maybe a justice in the current majority gets replaced by someone who aligns more with Kavanaugh and the dissenters, well, this currently unviable legislation might suddenly be upheld.
Because of those severe, immediate legal hurdles with passing a standard law, some argue there is actually only one legally sound way to do this, which brings us to Section 3, the constitutional amendment barrier. Attorneys like Carrie Severino, a former clerk for Justice Clarence Thomas, argue that an actual constitutional amendment is the legally correct direction for Republicans to take here. But guys, the requirements for that are staggeringly steep. First, you need a supermajority approval in Congress. Then, on top of that, you need ratification by 3/4 of the states. In today's hyperpolarized political environment, where numerous Democrat-led states strongly oppose the president's agenda, hitting that 3/4 threshold is viewed by basically all experts as virtually impossible. Constitutional law expert John Hsu summed up the chances of getting a supermajority in Congress with a bit of a laugh. He said, "Congress is so divided right now, they can't even agree on what should be in the House and Senate dining room menus." It's a funny, lighthearted quote, but it really highlights a stark reality. Achieving the necessary bipartisan consensus for a constitutional amendment right now is pretty much a complete non-starter. So if legislation is going to get struck down and an amendment is practically impossible, what on earth can the administration actually do today? That brings us to our final section, targeting birth tourism. To really understand this path, we first need to define the target itself. Birth tourism is a very specific scheme where foreign nationals use fraudulent documents, coaching services, and visa fixers to travel to the United States under false pretenses, simply to give birth. The ultimate goal of this entire scheme is to automatically secure U.S. citizenship for the child. Now, because this involves exploiting existing immigration and criminal laws, tackling it falls squarely within the executive branch's current power to enforce. And the administration absolutely didn't miss a beat pivoting to this strategy. Right after the Supreme Court decision, the Department of Justice issued a memorandum. Assistant Attorney General Colin McDonald came out strong, stating, "Regrettably, the American system is exploited each year by thousands of foreigners. We will bring illegal birth tourism to an end." He directly instructed U.S. attorneys nationwide to prioritize prosecuting these networks. So, what does this crackdown actually look like in practice? Well, experts have outlined a sweeping multi-agency dragnet that the administration can deploy without needing Congress to pass a single new law. Picture this: the Department of Homeland Security and the State Department suddenly imposing much stricter scrutiny on visas, especially for pregnant women coming from countries with a known history of birth tourism. Meanwhile, the DOJ is out there vigorously prosecuting the fixers running these schemes. Add in proposals to reduce welfare benefits available to immigrants and a really severe deterrent policy of deporting birth tourism participants rather than imprisoning them here in the U.S., it is a highly coordinated effort designed to create a completely hostile environment for the practice. Let's bring all this together and look at the realistic viabilities of these three paths we've discussed. The legislative path, amending the INA, has very low immediate viability, mainly because experts agree it faces an almost certain constitutional challenge. The amendment path, extremely low because the political math for a supermajority simply isn't there right now. Which leaves enforcement, cracking down on birth tourism as the highly viable path. It sits firmly within the existing executive authority of the administration, and, importantly, it can be implemented right now. Which really just leaves us with one massive, lingering question. We know the administration has the tools to aggressively target birth tourism today. But given the sweeping political promises made to completely end birthright citizenship for the children of illegal immigrants, will strict visa enforcement and targeted DOJ prosecutions alone be enough to satisfy that intense political push? Or are we destined to see this massive constitutional battle return to the Supreme Court a decade from now? Thanks for joining me on this explainer. I really hope this helped clear up the absolute legal maze surrounding this incredible story. Keep questioning, keep learning, and I will see you next time.